We have not. Good afternoon, Minister, members, and colleagues. We have not finalized that working out with the board and the council as yet. So we will get back to the committee on that. We are hoping that we'll be able to do so at the next meeting.
All right, thank you. I also note that
because that subclause is a big sub in terms of its entirety. Is there, and it made reference to 49.3 and 61.4. Are we satisfied that it does not impact any other clause or section?
We have not reached there as
isn't
yet. This is in relation to...
Or can you...
Hold on.
Remember, she spoke in relation to the board and the council.
The council, right.
Right.
And I just want to be sure time. Because we are trying here to that interface between the board and the council. And I just want to be sure that whilst that correction is being made, it also corrects any other future clause that may have been impacted by this. Yeah? So I just want to highlight that for due consideration by the technical team in reference to this.
Ms. Gordon-Jones, anything more to add to that particular issue?
In relation to the board and the council? No, Chair, not at the moment.
And could you or Dr. Gordon, who's online, speak to the surrender of a license or authorization to teach? I understand that there has been some rethinking of this.
That's the other matters arising?
We're still on matters arising, yeah. So
based on discussions after the last meeting, it was agreed that the clause that the committee had decided to remove, that's clause 61.4, that it's the other clause, which is 49.3, similarly, it was a decision to be made by the committee as to whether it should also be deleted based on the deletion of 61.4, which was a similar clause. So at the last meeting, there was a disagreement with Dr. Gordon in relation to retaining that provision, and so it is now the decision of Dr. Gordon that it can so remain deleted, and so it would be now for the committee to decide in relation to 49.3 based on the comments from the chambers through Mr. Foreman.
All right, Mr. Foreman, any comments from you?
Good. Oh, sorry. Yes. Good afternoon, Chair and members. No comments. The comment was there just to point out that there was an inconsistency between the two decisions and to invite the committee to reconcile them. So if the committee decides to maintain this power, then the two clauses would remain. If the committee decides that one of the clauses doesn't need to be there, then the two should go. So my comment was essentially about ensuring there's consistency in the bill vis-a-vis the decisions made by the committee.
So, Ms. Gordon-Jones, just repeat again which clause, which sub-clause will be deleted. Yeah.
So clause 61.4, it was a decision of the committee to delete that clause at one of its meetings. However, as Mr. Foreman indicated, clause 49.3 is a similar provision. And so the committee needs to decide whether it will also delete that provision, 49.3. 49.3. Can I read it from the old act? (49.3) states, and it's coming from the deregistration, revocation of registration, license or authorization to teach. It says the holder of a license or authorization to teach under subsection 1B shall surrender the license or authorization to teach by returning that license or authorization to teach to the registrar within, and for consistency it's changed from 14 days to 7 days at a previous meeting, of being notified in writing by the council of the revocation. And subclause 4 says, a person who contravenes subsection 3 commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000. So 61.4 reads similarly. And those two provisions were basically, the committee had decided to delete those provisions under 61, 4 and 5.
Is this where we take comments from Dr. Gordon about the surrender of the license?
It's for the committee to decide whether it's going to also delete 49.3 based on its decision to delete 61.4 before.
May I speak, Chair?
Yes, please go ahead, Dr. Gordon.
Sorry, I might lose my connection if I put on my camera.
No, just come on so we can see you and then you can go off.
I can't, yes, I'm here.
Okay, you can go off then if you have issues with bandwidth.
Yes, Minister, we had discussions among ourselves and with Mrs. Wilkinson, and we agreed that we would just delete the clauses and not request anybody to return the license to the council. Because with use of modern technology, we'll use electronic means to cancel the license if it is revoked.
That's great news. Go ahead, Member Gale.
I don't want to say it's a road to Damascus. However, the committee had agreed, based on Mr. Foreman's recommendation for us to examine it, to delete both to ensure consistency. And when you think about it, and based on what Dr. Gordon has just indicated, having consultations, there's no need for anybody to be, surrendering, especially under the circumstances which would have led to the revocation. And in fact, you really can't, based on the intention and the objective of the legislation, you cannot teach without providing that license and registration. So if you were revoked, then as indicated by the system itself would be applicable. And I remember, based on the research of the minutes and the extract, remember Green had indicated that all we have to do is to fix the system, to curtail this. And so we are at one with this now, no challenge. If I can speak on behalf of the committee.
All right, so the decision, committee members, is to delete subclause 14.9.3. We had already deleted 61.4 and, 49.3 and 4. And we had already deleted 61.4 and 5. All right, so approved?
Yes, Chair.
All right, so moved. If you move to, we're still under matters arising, page 6. About the third paragraph down on the page. Right, so this is still going on, and at the next meeting we'll come back with some kind of policy. All right, on page 8, at the bottom of the page, oh, sorry, put that on the record.
This issue has not been addressed by the technical team as yet, so we will have that information for the next meeting. That's in relation to clause 66, where it's currently indicating that anyone who is aggrieved by the decision of the council or a decision taken by the board of an educational institution or any other employer may appeal to the tribunal. So the issue was whether we are including private institutions in the appeals process by the tribunal. So I think it would be more of a matter of how we are going to word the provision, because I think it was clear that we could not include the private institutions, because it would mean that it's the entire system.
So, Chair, it was Member Braham, I believe. Was it? Right. Initially, who had raised this matter. So is it the intention or the objective of the technical team in the review of this to make a determination who it covers, whether it is the public as opposed to the private? or is it going to be a policy decision? And I am of the view, Chair, that any contemplation of this has to be based on a policy decision. Given the concerns that were raised, yeah? The intention of the legislation was to look at the entire system. But reasonably so, based on Member Braham, who is not here to understand that I'm supporting his arguments. A determination has to be made about for the intended separation. So it really, in my mind, first has to be looked at in terms of a policy direction. And once a policy direction has been determined and so defined, then it will guide the technical team. And I'm now wondering if the technical team is in agreement with what I've just advanced.
We are still to discuss it, sir.
Thank you, Dr. God.
Right. So we have to come back on because it's it's going to have to be a policy decision. All right, members, we'll move on to matters for discussion, and that will be the continuation of the review of the draft report on the committee's deliberation on the bill. Ms. Gordon-Jones. Continuation of the review of the draft report. All right, in terms of continuation, we are supposed to start at subclause 67(1)(a), but we also need to ratify the decision that was taken in a prior meeting for clause 67(1)(d). All right, so Member Gale, can I ask you to start at subclause 67(1)(a)?
(67)(1)(a), your committee noted a typographical error that the numerical 1 was inserted as a subclause before paragraphs A to D without there being a subclause 2. And so your committee recommends correcting the error with the deletion of subsection 1 and replacing the word complaint with the word appeal.
Chair, there was, I'd also made a suggestion to insert the word also so that it can be clearly indicated that it's two actions.
Two different actions.
Yeah. So it should read, and also replacing the word complaint with the word appeal. That's in 67A.
Yes, Chair. Now moving to 67(1)D. Your committee recommends the deletion of clause 67(1)D, which provides for the tribunal to hear matters ex parte. Your committee accepted that the rules of natural justice will apply. (68) Evidence before the tribunal. Your committee does not recommend any change to this clause. And 69, attendance at hearing. Your committee does not recommend any change to this clause. We move on now to subclause 69(1)(4). Says your committee recommends the insertion of the word, quote, in between the words give and evidence. In the second place where the words appear, the amendment would read, quote, a person served with a notice under subsection 1 shall not be compelled to give evidence or produce any document which the person would not be compelled to give in evidence or produce in any proceedings before a court. And so there were some comments now from the AG department.
Chair, just to interject, we had treated with this at the previous meeting, and so just a reminder that the committee had accepted the recommendation to amend the draft to remove in evidence. So it would be read not be compelled to give or produce in any proceedings before a court.
Shall not be compelled to give evidence.
To give, take out in evidence.
Yes.
So, member, the committee accepted the recommended amendment. Member Gale.
You have it. Yeah. So is that one you can just because the other route, so just yes, no. So yeah, so that was a reading, and this.
Okay. Yeah. It's okay now. Understood. So I can now move on to clause 70. Right.
Sorry, Chair.
Please go ahead, Mr. Foreman.
Yes, just a clarification, if I could just be reminded of what the decision was in relation to that last provision. It was to what? Remove the second reference, the second appearance of the word evidence in the clause.
All right, Ms. Gordon-Jones, can you
I had noted it, but I didn't.
That's correct, Council.
Okay, great. Thank you.
You're welcome.
So I can know clause 70, right to representation. And it says your committee does not recommend any change to this clause. Clause 71, decisions of the tribunal. Your committee recommends that the initial period within which the tribunal should give its decision to be increased from 28 days to 42 days. And subclause 71, 1A to C. Your committee recommends that the subclause should remain unchanged.
Based on clause 66, I think 71A to C would have to be revisited in relation to whether the appeal would be coming from the private institution as well, and also there would be the need to insert the PPCC in these provisions based on the recommendation to insert it at 66 of clause 66. So I'm just seeing that now. I'm not sure if the members
71
A to C. It says so it reads, on hearing an appeal under this part, the tribunal shall give its decision in writing within 28 days, no change to 42.
No change to 42.
Or such longer period as the tribunal may reasonably required, and may A, dismiss the appeal and confirm the decision of the council, the board of the educational institution, or the other employer as the case may be. C, allow the appeal and set aside the decision of the council, the board of the educational institution, or the other employer as the case may be. Or C, vary the decision of the council, the board of the educational institution, or the other employer as the case may be.
So in this case, the amendment we're seeking to change or propose is the other employer.
No, so clause 66 sets the pace for clause 71. And so if we are inserting the PPCC under clause 66 as an aggrieved, as where an appeal can be made against by a person who is aggrieved by the PPC's decision, then it would have to be inserted under 71 here. And also the fact that we are considering whether we are going to entertain the appeals from a private institution as well. It would also be to be treated, if we are intending on removing that, to be treated under 71 as well.
I think I may have misinterpreted. So if the consideration was in relation to the private institutions, I was assuming that the reference to private institution in this case would be the other employer.
Right.
Right. So it's two kinds of amendments in terms of the actions taken, to include the PPCC and to treat with the other employer.
Or it's currently treated.
Yes.
So the decision is whether we are going to maintain the provision as it is, or we're going to remove the private employer.
When you get back to us with that recommendation in terms of the policy decision.
Correct.
All right.
But for right now, we will include the PPCC in these clauses.
Yes, the committee can may wish to
can
consider
agree.
that.
Right. So that would be that part of it would prevail.
Yeah,
as opposed to the other.
right. All right. So that's an amendment on which this committee agrees.
Well, I'd love to hear from the other
The
committee
PPCC,
members.
to include the PPCC in clause 71.
Challenging.
So moved, members.
Well, I understand the intention, so I would agree.
Yes. All right. And then the other matter of policy, we will come back.
Would come.
Yep. All right.
So
Carry on, member.
we can now move to part 10, clause 72, regulations. Your committee noted the concern that the Act did not specify the time within which applications for the registration, licensing, or authorization to teach would be processed. Your committee was, however, directed to consider clause 72, which provides for the making of regulations which would address the issue. So your committee was satisfied with the explanation provided and recommends no change to clause 72 to address the concern. Subclause 72.1. Your committee noted the recommendations to add the words, quote, the Teachers College of Jamaica and representatives of the various educational institutions after the words, the council, in clause 72.1. The proposal put to your committee was for the bill to require consultations with the Teachers Colleges of Jamaica and representatives of other educational institutions, in addition to consultations with the council. Your committee, while agreeing that consultation should be specifically included in clause 72.1, was of the view that the requirement should not be limited to the entities suggested, and instead recommends that the minister should be given the discretion to consult with other stakeholders in the education sector.
Chair, not on that point, but just to crave your indulgence to recommit 71 on the basis that I'm seeing a notation where I'm not seeing it in the report, but there were discussions as to whether if the tribunal does not give its decision within the stipulated time, it can inform the parties and give reasons for the need for the additional time.
I can understand and appreciate that provision to be extended to a tribunal, because whilst it's agreeable for, in the first instance, to have a defined period, there can be circumstances where that tribunal, for whatever the reasons are, may require an extension. And a common practice in this instance is for the tribunal to indicate to the parties involved that it would require an extension. What is not normally given is what is that extended period. Because again, you would kind of confine the tribunal in terms of a specific period. So it is one of those provisions that allows the tribunal to get an extension, but also commits the tribunal to saying to the parties involved, we need an extension. And so in the understanding of the parties, it would give the tribunal that latitude in which to complete its decision or its award. Yeah? And so other tribunals would have somehow exercised that practice and privilege.
Member, do we need to limit the additional time? Or
No, you allow the tribunal the flexibility. And oftentimes, these are more extreme circumstances, yeah? Especially when you have a tribunal chair that would have been overwhelmed with all these issues to treat with. So I believe we could include that provision that gives the tribunal the flexibility, and also include it in the report coming out of these deliberations.
Chair, may I?
I yield to Mr. Foreman, and then I'll speak
All right.
after.
Please go ahead, Mr. Foreman.
Right. Oh, perhaps I should allow Mrs. Gordon-Jones to go ahead. I was going to say that I do recall the committee having a discussion about how to go about extending the period of time for the tribunal to deliver a decision if in those situations where extra time is needed. I don't recall what was decided or if there was a decision. So I'd perhaps have to yield to the clerk on that, and as well to my other colleagues if their memory is better than mine. But if a decision was taken, it would be appropriate to amend this aspect of the report to indicate that this matter was discussed and what decision was taken.
I believe, Mr. Foreman, in the first instance, I don't recall that a decision was taken. I remember the discussion, but a decision was not taken. Hence, maybe that's the reason why it was not reflected in the report. But I recall the discussion.
Right.
In fact, I may have been the one who raised it.
So Chair, my sentiments are similar to my colleague, Mr. Foreman, in relation to this point, and that's why we're asking time to check to see if a decision was made at the time of that discussion, and it would have caused the insertion of a new subclause to say that where the tribunal needs more time, then it's supposed to inform the parties and provide reasons for the need for the additional time. So we'll check back the records to determine, and we'll revisit at the next meeting.
The committee can decide, no, in terms of the additional time, no?
No. What I would recommend, since they are going to check if a decision was taken in the first instance, also you could also utilize the time to check the LRIDA, which that prescription, I don't want to say a provision, because I can't recall if it is in the provisions of the LRIDA or it appears under where the tribunal was given the latitude to make its own rules. But we can check. And since there's a time to review the records, we can also check the LRIDA.
All right, anything else to add, Council? Okay. Carry on, Member Gale.
We were at so I believe we did 72-1. So we move now to 73, rules, your committee does not propose any change to this clause. And then I move to 74, clause 74, service of notice. And it says your committee does not propose any change to this clause. There is clause 75, power of the minister to amend monetary penalties and first, second, third, fourth, and fifth schedules. Your committee does not propose any change to this clause. Clause 76, review of the Act. Your committee does not propose any change to this clause. And 77, amendment of enactments under the 6th schedule. Your committee does not recommend any change to this clause. Clause 78, Act binds the Crown, and I'm sure your committee would not have recommended any change to that particular clause. So we move to clause part 11, transitional provisions. Clause 79, interpretation of part 11. Clause 79, your committee recommends amending the clause to remove the reference of clause 83. Can I just look at clause 83 just to... Okay. Clause 80, current registration continues. So, in the marginal note, your committee recommends amending the marginal note to read continuation of registration and requirements for licensing and authorization to teach. And there would have been a comment should the word licensing or license.
We're asking the drafters to confirm that.
Well, 80 continues on page 29.
Sorry, just to say thanks to Mr. Foreman, rather than licensing, it's license. Requirement, so it would read continuation of registration and requirement for license and authorization to teach.
So that's accepted. And so clause 80 continued that your committee recommends an amendment to clause 80 to insert a provision that sets a time frame of 24 months in which persons who are deemed to be registered on the appointed day must apply to the council to be licensed or authorized to teach. So I gather that that we'll have to wait to see if, in the first instance, what that proposal would look like in terms of a provision. This is one of them that we may have to go look back at the minutes.
The provision, the inserted provision reads, a person who is deemed to be registered or enrolled pursuant to subsection 1 shall within 24 months from the appointed day apply to the council to be licensed or authorized to teach as the case may be.
So that means you have within 24 months to do so. Just off the top of my head, were there any requirements to acquire that license? All right. If qualifications, anything like that, to acquire the license. In other words, to attain your license, if there are any matriculation that is required.
From a teacher's college.
I just want to be clear.
Yes, yes, sir. Yes, sir.
Yes.
Yes.
It's set out in the document.
Go ahead, Dr. Gordon.
I am making, and I'm just really thinking that once you have a stipulation of a time period, if you are supposed to support within that time period, if there's anything that you need to acquire to meet that threshold, that it's only reasonable that you can do so.
Within that time.
Within that time frame.
Right, but remember this clause says that it's the persons who are already registered under the Education Act as trained teachers.
Okay.
Yes.
So there's nothing that binds the individual to do anything else but to utilize that 24-month period to acquire the license. Okay. So we move now to clause 81, registration of persons not currently registered at the appointed day. On the marginal note, your committee recommends an amendment to the marginal note to read registration, licensing, or authorization to teach of eligible persons. Sounds all right. And there's a comment now from the AG. The amendment to the marginal note does not accurately reflect clause 81. Note that a marginal note is to highlight the main idea of the clause. It is that the committee noted that the marginal note only provided for registration and not for licensing or the authorization to teach. If this is the issue, then the recommendation should be to insert those words in the marginal note. If the instruction is clear, the drafter will make the appropriate amendment to the marginal note. The amendment was made.
Chair, through you, we're asking Mr. Foreman to clarify that comment in order for the drafter to be so guided.
Mr. Foreman?
Yes, thank you, Chair. Not sure I can add anything to what's written there. I think this was a comment that's coming from the Solicitor General, and she's not here at the moment. I should tender an apology on her behalf. I think she's at LegCom on some other pressing matters. So I'd have to defer to a time when she is next in attendance at this session. I can say that I just had a look at the June 22, 2023 minutes. I'm not seeing specifically where this recommendation was made for the marginal note to be changed. So I'm not clear on the rationale for changing it in the first place. What I will note is that what's in the existing bill seems to follow a logical scheme insofar as the clause 80 is intended to deal with persons who are already registered within the existing system and to make provision for them to become part of the new system. And clause 81 deals with persons who are not now registered under the existing system and to make provision for them to come into the new system when that comes about. So there seems to be a coherence in what is in the bill at the moment. And I don't, as I said, I don't quite recall what prompted the recommendation for the change to the marginal notes. So unfortunately, I can't provide much help beyond what I've just said.
Maybe before we get back, the technical team could consult outside of these deliberations and get back to us. So I would now move to subclause 81.3. Oh, sorry.
Yes, we will not detain the meeting for the marginal note, so we will consult the technical team to ensure that the marginal note is properly reflected, and we will advise the committee of what the reading should be.
All right. So, subclause 81.3A, your committee was informed that at the time of the establishment of the council, that it was a negotiated position by the Jamaica Teachers Association, because teachers are being registered under the old act. We noted that there was no registration fee and that teachers were registered according to a set of criteria, and we highlighted that licensing carries a fee because it is a practice. Your committee recommends that the clause be amended to delete the reference of 12 months and substitute 24 months. Your committee also recommends deleting the words registration and from the provision. And I would invite the technical teams to look at the comments and guide us.
I'm looking at Mr. Foreman's comment. I think at the initial stage when the bill was being reviewed, Clause 80 at the time that treats with persons who are currently registered did not properly reflect, or it did not give time for those persons to be able to get that time to get their license or authorization to teach. And I think it was that misunderstanding that led to the removal of the term registration here. But as Mr. Foreman rightfully indicated, this provision treats with those persons who are not currently registered under the bill and would need to be not only licensed or get their authorization to teach, but also be registered. So I think the removal of the term registration would not be a correct thing to do based on those circumstances.
Chair, what the statement of Ms. Jones is correct.
So, Chair, if I may, so if, based on what has been said by Mrs. Jones and Dr. Gordon, if the committee accepts the observation that was made, what would happen is that that last sentence would just be deleted from the report.
So, could you just read that last sentence there, Ms. Gordon-Jones? Mr. Foreman, which last sentence?
In the report?
In the report?
Was it the last sentence in the report, Mr.
The last
Foreman?
sentence in relation to subclause 81.3a. Your committee also recommends deleting the words registration and family provision.
So that's the sentence you're saying that can be struck out?
Right, because if the decision is to maintain what is in the bill at the moment, removing that sentence from the report would maintain the status quo.
Okay. I put that to the committee.
Chair, do I proceed? Oh.
To Chair, we're retaining the term registration under clause 81 with the committee's permission. And in terms of the period, it currently reads 24 months or such longer period as may be prescribed. We have noted that that latitude was not given to the minister in relation to those persons who are currently in the system under clause 80, who would be given the same 24 months within which to apply for their license or authorization to teach. And so we are making a proposal for or such longer period as may be prescribed be inserted under the new clause, subclause 82, where it was agreed that the provision be inserted to allow for the 24 months for those persons to be licensed or authorized to teach.
All right, so you're putting that in both 80. Huh? You have a question, member? You're putting it in 80. You're recommending to put it in clause 80 and 81.
So it's currently in 81.3. It gives the minister the latitude to prescribe a longer time if they need more than 24 months. However, for those persons who are currently in the system, that will be given the 24 months to be licensed or authorized to teach. The minister does not have the latitude to maybe prescribe a longer period. So we are proposing that that be inserted.
So, all right. So we are being consistent with in the first instance with the 24 months. And so you are proposing that in addition to the consistency of the 24 months, you are now giving the minister the latitude to extend it. Just from my understanding, I just want to be clear, what would be the rationale for giving a minister the latitude to extend? Under what circumstances would apply?
So currently, the teachers who are currently registered or authorized to teach will be deemed registered and authorized to teach from the appointed day.
Right.
They have 24 months within which to apply for the license
right.
or authorization to teach. Maybe the council may need more time to treat with those license and authorization to teach. So the teacher might apply within the time frame, but because the council
So because the council may need some more time, I just want to, in this instance, that it can't be arbitrarily said that because there's a provision that allows the minister the extension, there has to be a trigger to that call that would require the minister to extend, and that a minister won't take it up on themselves without having a trigger of some sort. And in this case, what you are suggesting is that the council may request that it needed some more time and make that appeal to the minister and by virtue of any justification presented, then the minister would give the extension. When you make a provision of that nature, it has to be something supported by a trigger of some sort. And so the minister would be acting on that trigger. And nobody can say, and everybody comes, that for an extension. That may include a teacher, without any reasons or rationale.
If I may, just to indicate that we have used the word may. So it's a case in which it doesn't have to be used, but a circumstance may arise where the minister has to make a decision and say, okay, I'm going to allow another 6 months for teachers to regularize themselves.
You see, again, the use of the word may. Anyone who utilizes that provision may or may not. And I want to ensure that whatever provisions that we are putting in place that gives that, it doesn't give an instruct. It's no obligation whatsoever so to do. But for the abundance of caution, if someone requests, or for whatever circumstances there may be, the minister acting on that provision would always be viewed as being reasonable and fair. I don't know if we can have circumstances, and that's why I ask for some trigger of some sort. Because somebody might come with a frivolous reason. And if the minister may or may not, that minister might be viewed as being unfair and unreasonable. Yeah? I like to have thresholds. I like to have triggers of this nature that someone can point to within reasons that would recommend an action of these sorts.
And in particular, since we moved the time frame from 12 months
it is
24 months.
So we're moving the time frame, from 12 months
and these are teachers
to
who
24
are already
months.
in the system.
And then we're saying, Chair, that you're giving the minister the authority to extend that from 24 to possibly another to 36, whatever it is. So we have an established time frame in the first instance. And in furtherance of that time frame, there may be requirements to extend it. But I like to have safeguards in place that triggers those requirements. It could be, but we're not going to say that. But somebody, and I mean, you are the drafters. I'm only applying the thought process as best and as practicable as I can in the protection of not only the process, but the minister who would have to act. can we just think about any other associated provisions that could be inserted to capture this? If so, and I'm going only by the recommendation that was made, and I was just seeking a rationale and a justification. The second point I want to make, Chair, is that so there was an understanding that the last sentence would have been deleted, but now you're saying to us that you would want to retain it in the report. So where are you saying that you now want to retain it? Retain the word registration in the clause itself. Okay.
So this we're overwriting, or Mr. Foreman said, or, oh, this is from the report.
No, I understand it in the first instance as the deletion would take place from the report
From
itself.
the report, yeah, but we're saying to retain it in the report and to also...
No, delete it in the report. Delete the last sentence from the report itself.
Okay.
But in the
retain,
clause,
right.
it is being suggested for the retention
of registration.
of reward registration.
And or just registration.
Once the sentence is deleted, it would mean the recommendation be no longer applicable, and so it would have to revert to the status quo. But Chair, I listened to Member Gail speaking about the rationale for the inclusion of or such longer period as may be prescribed. So are you saying then that Clause 81 ought not to have those words? Because Clause 81 currently has those words. So, I mean, for consistency. Are you of the view
We're in Clause 81.
3A.
3A. The expiration of a period of 12 months or such longer period as may be prescribed, during which the person may apply for registration and license as a teacher or the authorization to teach under this section. No, maybe I'm not seeing. Maybe I'm not seeing the application of this extension.
Which extension?
We're talking about where the minister extends from the 24 months.
So you just read that provision? Under 81.3A. So what we were proposing is to insert similar wording on the 82. New 2. So you would not
the
see
new
it under
82.
that one.
Okay. So you would have what is referenced in 82 now would be 82.1.
80 subclause 2. So you would not have that in the new bill because in the bill because it's a new provision. So 80 subsection 2 was inserted to allow for those teachers who will be deemed registered on the appointed day to apply for their license or authorization to teach within 24 months.
Within 24 months. We moved that 12 to 24.
There was no provision before.
Right.
So that is currently inserted to allow them 24 months within which to apply.
Right.
However, it did not say or such longer period as may be prescribed, similar to what is currently in 81(3)(a).
I get you now. Yeah? For consistency. And so the authority in this case is to give the minister at this as such period that may be prescribed, that the minister can prescribe further extension. Where I want it to be sure is that
would be
it would not
right?
just be arbitrary.
But,
no, man.
But
so
remember,
again,
Gail, it sounds like though it would be applicable to everyone if you have that extension.
If you have that extension.
Person, yeah.
But the minister from time to time, given reasons, would come back and prescribe an extended period. It would not be a poor occasion. So the minister may recognize, because of circumstances that continues to prevail, that it would require not 24 months, but 36, because of a consistency of actions and challenges taking place, which would deem it necessary to prescribe an extended period. So you're changing the period from 24 to 36. The period now becomes 36, and not an isolated occasion based on a call from. So be clear with me now, and I beg you to exercise patience with me, because I may be the slowest member of this committee. Is it viewed that this is a one-off situation that would cause the minister to extend the period? So in other words, because of the one-off situation that caused the extension, the period would still be 24 months. So it would move to 36, and it creates a new extended period of 36. But because of the isolated situation, it would cause the minister to extend it. Well, since I was on the record, your nod would not apply on the record.
Yes, member.
All right.
So once the 24 months has passed, there wouldn't be any need for clause 80 anymore.
All right.
Because it's expected that the teachers would apply within the 2 years. So
all right.
So you're agreeing?
I now understand. That puts me in a position to agree.
Very well. Chair, over to you.
So
go ahead, member.
Move to 82 now.
Committee members, I put to you the amendment to clause 82, subsection 2, to include that the minister may extend the time for how long? Or just for such period as may be prescribed. Committee members? Member Miller? Okay. Member Garvey, sorry, do you want to make an intervention? Not hearing anyone. It looked like Member Miller wanted to say something, but your mic is muted. He's not hearing? We're not hearing you. You want to write that you agree? Okay, so he wrote. They're not hearing, but Member Miller wrote in the text that he agrees. All right. Thank you, members. All right. Member Gale, let's move on.
Is anyone online hearing us, just to be sure?
They are hearing, but we are not hearing them.
Mr. Foreman, who would have participated? Mr. Foreman, just say something now, please.
Something.
Okay, good. Just checking. Thank you.
You're welcome.
There's some humor in you, Mr. Foreman.
So I can now move on to 82. So it says, your committee recommends the deletion of the clause because it is a repetition of clause 80 and to ensure alignment with the bill that was tabled. Yeah, it spoke about the every person. So if we delete that clause, it now changes the numbering. Huh? No, I'm not going to worry about it. I was just thinking aloud. So, 83 orders made under the Education Act. It says, your committee notes that consequent to the recommendation to delete clause 82, that the subsequent remaining clause should be, renumbered accordingly. Your committee recommends amending the clause to refer to the PPCC instead of the council, in accordance with its previous recommendation to empower the PPCC to make disciplinary decisions. And then clause 84, transitional provisions, general. Your committee does not have any recommendation for clause 84. And clause 85, transitional provisions relating to employment. It says an update may be required pending further review. '85, transitional provisions relating to employment. and maybe I believe it's 2 and 3 specifically. No. So what 85 is speaking about is its provisions in relation to employment. So 85(1), subject to the provisions of this section, on the appointed day, a person holding an appointment or assigned to an office under the existing council shall be transferred to the service of the council established under the Act for a period of 6 months or such longer period as the council may, in special circumstances, determine. So hold on right there. Is that suggesting a probationary period for transitioning? So under the existing council, you would have been employed from day one. Is this saying that under the application of the Act, for a new period or such longer period as the council may, in special circumstances, determine? Is this calling for a probationary period? And before I give a response, I'm asking that. You want me to go out read the entire provision? So 2 says, the Governor General may, subject to such conditions as the Governor General may impose, approve the appointment of any officer employed in the service of the government to any office within the council, or conversely approve the appointment of any officer employed with the council to the service of the government. So that's moving from one to the other. And while so employed, any officer so appointed shall be treated in relation to any pension, gratuity, or other allowance, and in relation to other rights as the public officer, as continuing in the service of the government. So what it's doing there, is the provision of your entitlement and the duration of your employment. Yeah? So if you move from any area in government and come into the education system, there's a security in tenure and provisions, so that you are no worse off. 3, a person who held an office or employment under the existing council under a contractual arrangement shall from the appointed day be deemed to continue to be employed to the council established under this Act on terms and conditions that are no less favorable than those enjoyed by the person in the substantive position of that person on the appointed day. So this is speaking now to those who may be having fixed-term contracts, and that in transitioning, they are no less favorable in terms than someone who would have held a substantive position. So this is creating and ensuring equity. But I just need some clarity on 85(1). If 85(1) is prescribing that the transitioning of the person is suggesting that there should be a period of 6 months or such longer period, as the council may, in the special circumstances, determine. What would have triggered that? Why this assumed probationary period? So you're already holding an appointment or assigned to an office under the existing council. That's a sense of security already in place. But if you are transferred to the service of the council established under this act, when this act comes into place, you're now deemed to be operating possibly under a period of 6 months or longer that the council may decide. Why? What would have been those special circumstances? Is this a new thought of an amendment, or this provision came from somewhere else? From the 1940s.
Sorry, Chair, if I may.
Please go ahead, Mr.
Yes, I think this is one of those provisions that you typically find in legislation where a new entity is being created to take over one that's already existing. The essential purpose of it is to facilitate transition in respect of employment from the old to the new. So the idea is to continue with the existing staff with some flexibility to determine whether everybody that's there now needs to continue. Maybe some people want to move on, and things of that nature. I'm trying to find some examples of a similar provision in other types of legislation of this nature. But that's the essence of it, to transition from one employment situation, which would be the employment no under what exists, to employment under what is a new entity, a legally distinct entity. But I'm searching for some other examples that the committee can look at.
All right, Mr. Foreman, I await your checks, but just the reading of this sounds pretty harsh. I think that new entity will have plenty time to figure out, right, what they need to figure out. But on just reading it on the surface without the benefit of what you will come back with, this clause as a transition clause sounds a little bit harsh.
Chair, Mr. Foreman has indicated that he intends to search. And I'm hoping that that search is an exercise in futility. And I'll say why. So, we are moving from one entity to another, legally. But I would make an assumption that the objective of this transitioning also would be to ensure the transitioning of the skills and for the retention of those skills as part of the transitioning. And we run the risk of losing the skill set if we make the terms of the transitioning insecure. And the insecurity in this case is that we would be taking these persons from the existing operations to make them into what the legislation is proposing, but to transition them in an insecure manner by placing them under a probation that the council would also determine if they need to extend it. So if I don't like you, I'm going to place you on probation. And we don't know, is it everybody that is going to be placed on probation? I think that intention by the proposal of this legislation would create the most insecure transition in the first instance and put a burden of anxiety and fear among anyone who is trying to transition. I believe in the first instance the council should readily want to ensure that you carry over the skill sets with either the same terms and conditions of employment or better. I couldn't support this. And then now, it is the approach itself is contrary to what is applicable in subclause 2 and subclause 3. Because subclause 2 and subclause 3 promotes the security, promotes the transitioning from either side, wherever you may come from. So I'm hoping, Mr. Foreman, you don't find nothing else in the in government that suggests that. And maybe that's why there was that indication in the report that an update is required in relation to this. So, Chair, if I'm the only member of this committee that is responding on this matter, 85-1 does not have my support in the manner in which it's being suggested. You know, this is one of the times when I miss Member Brown.
So, Council, we're asking for this clause to be reviewed. Actually, we'll also wait to see what Mr. Foreman comes back with. However, I am not in agreement either that we should have this period of 6 months or such longer period as the council may, in special circumstances, determine. It just sounds like we're mixing a lot of things that shouldn't be mixed. We're transitioning to a new body. I agree with Member Gale, you need the skill sets to transfer, and you need them transferred in an orderly way, not under duress or, you know, with insecurity. And so I'm supporting what Member Gale is saying.
So Mr. Foreman would also have raised the possibility that some persons may not want to transition, which is real. And I'm speaking about the part that says, shall be transferred to the services of the council established under this act. So there may be those situations where persons might not want to go. They don't want to go into this new frontier. And we have seen where in these transitions, there are persons who say, I don't want to go. I prefer to exit. And there are ways established in law that you can exit. You
also have those persons who are on contract that might have a substantive post
somewhere else or somebody on secondment.
Right.
So those provisions, you see, I wouldn't necessarily put that in legislation. Yeah? There would have to be some guidelines that surrounds this kind of intention rather than put it in legislation. Because when you apply it in legislation, you commit to a kind of action that does not allow that other type of flexibility to which may come forward. Yeah? And so we really have to consider what is the intention of a 85-1.
We need 85-1 member, but just not the clause that says
in the way that it is being suggested here.
Yeah, not. Well, we need to delete.
But if not, you need 85-1. I need 85.
The period of 6 months or such longer period, as the council may, in special circumstances, determine. That needs to come out.
Hi, Chair.
Please go ahead, Mr. Foreman.
Right. Given the time, this may be one of those matters that has to be addressed in more detail later on. But in terms of similar type of examples, the Integrity Commission Act also has some transitional provisions in there related to employment. As the committee is aware, the Integrity Commission took over the functions of the then Office of the Contractor General. So there was a need to ensure that there were provisions in there to treat with the powers of the Contractor General now subsumed under the Integrity Commission and those who were employed under that entity and so on. So Section 62 of that legislation, it's a bit more detailed than the transitional provisions in the bill, but I'll just read maybe the first two subsections of Section 62 to give an example of the types of provisions that typically are employed in these types of situations. So Section 62(1) says, subject to the provisions of this section, on the appointed day, all persons holding permanent appointment to the offices under the Commission for the Prevention of Corruption, the Integrity Commission, or the Office of the Contractor General, hereinafter referred to as the respective commissions, shall be transferred on secondment to the services of the Commission established under this Act for a period of 6 months or such long a period as the Commission may in special circumstances determined. So that's a similar idea to what is now contained in subclause 1 of clause 85 in the bill. Then going back to the Integrity Commission Act, subsection 2 of section 62 says, pursuant to subsection 1, during the period of secondment to the commission, an officer shall be employed on such terms and conditions as may be determined by the commission, being terms and conditions that are not less favorable than those enjoyed by such person in his substantive position on the appointed day. So this provision ensures that whatever contractual arrangements existed under the predecessor entity continue to apply to this person for the period of secondment. And then the next subsection says an officer who is transferred on secondment pursuant to subsection 1 may be deployed in the public service on or before the expiration of the period referred to in subsection 1 on terms and conditions that are not less favorable than those enjoyed by the officer in his substantive position, or be retired on the ground that his substantive position has been abolished by virtue of this section. Subsection 4 says all persons who on the appointed day held offices under any of the respective commissions under a contractual arrangement shall from that date be deemed to continue to hold under the commission established under this act the like or similar respective offices of employment on the same or no less favorable terms as they held those or similar offices under any of the respective commissions. Right, there are 2 more subsections, just for completeness. Subsection 5, a person who has served in an office established under, and it lists the various legislation, and would have, but for the repeal of this respective act, been eligible to receive a pension, shall be paid a pension where such service together with the person's service under this act amount in aggregate to not less than 7 years. And finally, the commission may, where it is satisfied that it is equitable to do so, make regulations to be given respective effect for the purpose of conferring a benefit or removing a disability attaching to a person who may have been entitled to a pension in the circumstances provided for in subsection 5. So this is one of those types of transitional provisions that one might typically find in legislation where a new entity is being established to take over an entity that already exists. So that was the type of example that I had in mind. From what I've read, you can see that the wording isn't quite the same as what's there, which that's not necessarily, nothing's necessarily wrong with that. But those are the types of considerations that usually apply in relation to the transition of employment from an entity that is being replaced by a new one. And the committee can deliberate on exactly what it wants to
all right. So thank you for that, Mr. Foreman. That was, I was hoping you'd have taken a longer time and not come back with anything. But anyhow, that was one of those transitional employment type that was expansive in nature. But and I'd like to review that by looking at it in a very detailed way to examine its intent and its purpose and what it was seeking to achieve. I listened, and there are some continuous protective clauses entrenched in those provisions. But I recall the first clause you read spoke about maybe possibly bringing 3 entities into one. Am I correct? 3 entities into one that would form the now Integrity Commission.
That's correct.
All right. And in those circumstances, it normally, based on my experience, because of the history the culture and the provisional requirements from 3 different entities coming into one. I've seen situations where employees might want some time to make up their mind if they want to belong to this new entity with different culture, mindset, and objectives. And so that type of transitional requirement would apply. In the case here, it's different. It is one entity transitioning to a new entity that is going to be established based on a new legislation. In that first clause that you read also, if I can recall, there may have been some persons on secondment. And so, it also gives them the opportunity as part of the transitioning, if they so wish and desire, to remain on secondment, or they would want to take up the new terms under the Integrity Commission. And again, we don't know if those new terms under the Integrity Commission may have been greater than where they are coming from. And so in the pursuit of the transitioning, an employer may decide that if you're coming into this, you're coming under some new terms and probation because of the possibility of enhanced provision under the new entity. So there are some determining factors that are usually employed for these kinds of transitioning. And whilst the representation of what you would have entailed there are different in nature as given the numerous clause, it is worthy to clinically review it and for a determination to be made if the intention of what we are discussing now would be the same intention as to what would have been prescribed from that entity. So I would ask you to send the clerk the details so that we can further review it and help the determination of this particular clause in our future deliberations.
Thank you. Noted, Senator. I've added in the chats. I think Mr. Nash will see. So I've also included the Tax Administration Jamaica Act 2013, which essentially involved one entity transitioning into a new entity. The language is also similar. So the employees in the existing entity transferred on secondment to the new entity for a certain period of time, with measures in there that says you can't be on less favorable terms, and also provisions that allow for persons to be deployed to the public service as well, and a provision as well to deal with persons who are on contract.
But I'm putting it to the committee and these deliberations because we use the term in other supporting clauses of these objectives and intention around no less favorable term. No less favorable term does not only entail your remuneration and any attendant allowance. No less favorable term includes, I'm humbly suggesting, your tenure of employment and security. It can't be a favorable term that you are transitioning to any greater rate but you must go on probation. It can't be. No, but this is saying the question of the 6 month, right? The question in the first instance that you're speaking of shall be transferred to the service for a period of 6 months or such longer period as the council may in special circumstances determine. I start under the existing arrangement all my life. As someone would have said, I come in short pants or skirt. But I've given all my years of service, and I'm now transitioning because of an abundance of a new legislation that I must go start over for 6 months for somebody to determine whether or not I meet the requirements of this new entity and I have all the skills and experience. No, it is not the same terms and conditions of employment. And even if it would have been established elsewhere, that may not have been an appropriate practice to the fairness and to the reasonableness of those employees. Can you imagine what those employees at those institutions that you would have referenced would have gone through during that period of probation? And in an exercise like this, I would have indicated the need for the retention of the skills. And people do have opportunities. And I'm saying that the council would require the expertise of these skills. And this is something that I know Dr. Gordon would readily agree with me on. I'm not supportive of this kind of practice. And this seems to be an element that has surfaced itself in the labor relations and employment relations. It does not say that it's good for employees.
Member, I am in agreement with you, and I like the example that you used as well. If you're merging 3 different entities with 3 different cultures and so on that you may want, you may look and see there's going to be overlap or duplication of duties. But in this case, as you indicated, it's pretty much the same entity, just under different regulations. So I am in agreement with you to eliminate this requirement for the 6 months, or just the whole question of leaving it up simply to the council to decide, on what your new terms of employment should be in the new entity, especially if you've been working with the existing entity for some time. All right, members, I believe we
So are you suggesting, Chair,
I'm
we leave it right here for today?
Yes.
I agree that we can place the emphasis on thought as to where we're left off before we trigger any other deliberation. And also, Chair, the reference to the intention of this particular clause is really a policy decision. In that you really want to secure your competence and your skills. No employee should be placed under those burdens of anxiety and stress.
Agreed, member. And with that, for our next meeting, we will continue at clause 85. Let me just find the dates of the next meeting. No.
That's it. We just watch it.
All right, so we have 2 meeting dates, well, proposed meeting dates. Oh, just one, sorry. Thursday, June 27, 2024 at 2 p.m. Sorry, wrong date. All right. All right, so the first proposed date would be Thursday, June 20, 2024 at 2 p.m. Yes. And then the 20th at 2 p.m. and then as well Thursday, June 27 at 2 p.m.
So I won't be here on the
27, okay.
So I'm really close to the 7th. I won't be here on the 20th.
All right, so let me thank everyone, those who are here physically with us and those who are online, our members, our technical team. Thank you so much. I know that we've been going at this for some time, but I can see the light at the end of the tunnel. Thank you for your dedication to this process, and I'll see you back here on June 20th at 2 p.m. All right, thank you, everyone.